All right, I will now call this meeting of the Senate Judiciary Committee to order. Will the secretary please take the roll?
Senator Flores?
Present.
Senator Orenshaw?
Here.
Senator Lang? Senator Wynn? Here. Senator Hansen? Senator Krasner? Senator Ellison? Chair Scheibel?
Here, thank you so much. All right, we have a busy agenda today. We have a work session, we have a bill hearing, we also have a BDR introduction. So we will start from the bottom and work our way up, beginning with that BDR introduction. The members of the committee have a couple of copies of BDR 15-1038. This is a proposal from the governor. It includes various provisions related to criminal justice. It is many pages long, 133 to be exact, so we are sharing these copies. And I'll remind the committee that moving to introduce the BDR as a bill is not an indication of your support or lack thereof for the policy proposals therein, but simply an administrative decision to introduce the bill. So at this time, do I have a motion to introduce BDR 15-1038?
So moved, Madam Chair. Second.
We have a motion from Vice Chair Flores, a second from Senator Orenshaw. Any discussion on the motion? Not seeing any discussion. All in favor say aye. Aye. Any opposed, nay. All right, by unanimous vote, BDR 15-1038 is introduced. That takes us to the next item on our agenda that we're going to address next, which will be our work session. While I have everybody here, as you know, it is that time of year when members will be coming and going, and just as a reminder, members will be coming and going. They are going to other committees. They are not trying to avoid you. And please don't take it as a sign of disrespect or lack of interest in your bill if they have to go present their own bills or something like that in another committee. So while I have everybody here, let's go to our work session, starting with SB 35 from the Attorney General's office. I will turn it over to our policy analyst, Mr. McDonald.
Thank you, Chair. This is Jared McDonald, Research Division, LCB. Senate Bill 35 revises provisions governing certain offenses related to prisoners. It was sponsored by this committee on behalf of the Attorney General and heard on March 10th. The bill enhances the penalties for an employee of, a contractor, or volunteer for a prison who communicates with a prisoner for prurient or other illegal purposes, or with an intent to arouse, appeal, or to gratify his or her own sexual desires or the sexual desires of a prisoner. We have one amendment proposed for this bill, and this was brought forward by the Attorney General. And this amendment will delete Section 1, and that is the part about communications with a prisoner for prurient or other illegal purposes. Thank you.
Thank you, Mr. McDonald. And you all may have noticed that that amendment is new since our hearing. It does remove Section 1 of the bill. Are there any questions on Senate Bill 35? I don't see any questions. I would accept a motion to amend and do pass. Oh, I'm sorry. Is there a question? Senator Ellison.
Madam Chair, thank you. I'm going to vote yes to get this out, but I'm going to reserve my rights, and the reason that is I'm still trying to see if Washoe and the sponsor of the bill is going to be able to come to a conclusion, if they can, on an issue on the bill. Thank you.
All right. Thank you. With that, I will accept a motion from Senator Wynn to amend and do pass. Was there a second? All right, with a second from Senator Hansen, any discussion on the motion?
As amended, right?
Yes, as amended. I don't see any further discussion, so all in favor of SB 35 as amended to move to amend and do pass? Aye?
Aye.
Any opposed, nay? By unanimous vote, SB 35 will be amended and passed out of committee, and I will assign the floor statement to a volunteer. But not seeing any. Oh, Senator Wynn, it's yours. And that takes us to SB 258. Again, I'll turn it over to Mr. McDonald.
Thank you, Chair. Senate Bill 258 revises provisions related to industrial insurance. This was sponsored by Senator Wynn and others and heard on March 26th. The bill limits the reduction of compensation payable to an employee, including future compensation, to a reduction based on the portion of any amount paid or the portion of damages or proceeds recovered which represent economic damages. And I will stop there because there is an amendment for this bill that essentially deletes all the proposed language in the original bill and replaces it with a new section that clarifies that the amount recoverable by the insurer or administrator shall be the lesser of the full amount of the lien or 1/3 of the total funds recovered from the third party. And you can take a look at that amendment starting on the next page. Thank you, Chair.
Thank you. I have a question on SB 258 for the sponsor. Does the amendment reflect an agreement between all of the stakeholders?
Yes, it does. I see many of the stakeholders here, so if you have specific questions about what the amendment does, I think they would be able to do it, be able to answer those questions, but it does. It brings either everyone in support or in neutral.
Wonderful. Excellent work, Senator Wynn. Any other questions on SB 258? All right, not seeing any other questions, I would accept a motion to amend and do pass.
So moved, Madam Chair.
All right, I think we actually had a motion from Senator Lang first. I'll take Senator Flores as second. Any discussion on the motion? Not seeing any. All in favor say aye. Aye. Any opposed, nay. And by unanimous vote, the committee will amend and do pass SB 258, and I will assign the floor statement to Senator Wynn. That takes us next to SB 263. Mr. McDonald.
Senate Bill 263 revises provisions related to pornography involving minors. This bill was sponsored by Senator Cannizzaro and others and heard on March 19th. The bill expands the prohibition against the preparation, advertisement, or distribution of child pornography to include computer-generated child pornography. The bill also revises the applicable criminal penalties by subjecting each person found guilty of violating the prohibition to a term of imprisonment in state prison, and providing that a person who is found guilty of a second or subsequent violation is guilty of a Category A felony. And we have no amendments proposed for this bill. Thank you, Chair.
Thank you, Mr. McDonald. Questions on SB 263? I'm not seeing any questions, so at this time I would accept a motion to do pass. All right, we have a motion from Senator Wynn to do pass. We have a second from Senator Lang. Any discussion on the motion? Senator Orenshaw.
Thank you, Chair. I still have a few questions for the sponsor. I'm going to vote to support it out of committee and reserve my right.
Understood. Thank you. All right, not seeing any other discussion. All in favor say aye. Aye. Any opposed, nay. The bill moves unanimously to do pass from committee, and I will assign the floor statement to Senator Cannizzaro. That takes us to SB 341. Mr. McDonald.
Thank you, Chair. Senate Bill 341 revises provisions related to criminal procedure. This was sponsored by Senator Orenshaw and heard on March 31st. The bill removes the authorization for a witness to testify at a preliminary examination or grand jury proceeding through the use of audiovisual technology on the ground that good cause otherwise exists to allow the witness to testify, requires the witness to sign a sworn written declaration at least 10 days prior to giving testimony, the state to file a declaration with the court as soon as practicable but not later than 5 days before the preliminary examination or grand jury proceeding, and requires the state to file together with the declaration a notice stating that the reason why it is necessary for the witness to testify at the preliminary examination or grand jury proceeding through the use of audiovisual technology. And we do have an amendment that was proposed for this bill, and it was submitted by Senator Orenshaw. And this was discussed in the hearing, but you may recall that the bill proposes to amend Section 1, Sub 2, Paragraph B, and Section 2, Sub Paragraph 2B to remove the requirement that a witness must sign a sworn written declaration at least 10 days prior to giving testimony, and requires the state to file the court both the declaration and a notice stating the reason why good cause exists for the witness to testify at the preliminary examination or grand jury proceeding through the use of audiovisual technology no later than 48 hours prior to the time set for the hearing. And that is all we have for that bill. Thank you, Chair.
Thank you. Any questions on SB 341? All right, not seeing any questions, I would accept a motion to amend and do pass.
So moved, Madam Chair.
All right, we have a motion from Senator Flores. We have a second from Senator Nguyen. Any discussion on the motion? Okay, I'll start with Senator Krasner.
Thank you, Chair. I'm going to vote yes to get it out of committee, but I want to reserve my right to change prior to floor. Thank you.
Senator Ellison.
Thank you, Madam Chair. And I did get a chance to talk to the sponsor a few minutes ago, and I still got a few discussions to understand on the 10-day versus the 48, and then I found something else in my notes, so I'm going to vote it out of the committee. I will get with the sponsor of the bill and make sure they'll go over it. If that's the case, then I'm fine with it. But thank you.
Thank you. Any other discussion on the motion? Okay, Mr. Wilkinson.
Thank you, Chair. I just had a quick question for Senator Orchel about the intent of the amendment. Is the intent to get rid of the good cause otherwise exists that's an existing law, or is that being added back into the statute?
And thank you, through you, Chair, to your committee counsel. My intent with the proposed conceptual amendment was to keep the deleted language at section 1, that's at NRS 171.1975, deleting the language that's in the bill at page 5, or if good cause otherwise exists, that's at lines 5 and 6. Additionally, to delete it where it appears again in section 2 of the bill, that's at NRS 172.138, at lines 36 and 37, to delete that or if good cause otherwise exists. And then to change the language in subsection 2 of section 1 to the language in the proposed amendment at section 1 subparagraph 2, and additionally as well in section 2 subparagraph 2.
Okay. The reason I was asking was the last requirement you have in the final sentence there, where the state has to file with the court the declaration and a notice stating the reason why good cause exists for the witness to testify at the preliminary examination through the use of audiovisual technology. If the grounds are only residing more than 100 miles from the place of the preliminary examination or grand jury proceeding, or being unable to attend because of a medical condition, I was wondering why we're referring to good cause existing if that's being deleted.
And through you, Chair, to legal counsel, that could be an error in the way I wrote the conceptual amendment, because certainly my intent is to no longer have that or if good cause otherwise exists exception, and to have the distance and the medical condition be the triggers.
Okay, I will fix it accordingly.
Thank you, Mr. Wilkins. Thank you, Chair.
Yes, go ahead, Senator Ellison.
Thank you. Does this still allow for the video conferencing with that change in the bill?
Thank you. And James Orchel, Senate 21, through you, Chair, to Senator Ellison.
You can go direct.
Oh, direct. Okay, thank you, Senator Ellison. My intent is that it would be allowed. However, there would have to be notice, and it would be based on the distance requirement, the 100 miles from the place, either the preliminary examination or from the grand jury proceeding in Section 2, or because of a medical condition, would be the two reasons for which it would be allowed. Notice would have to be given to defendant and defense counsel 48 hours under the amendment.
Okay, thank you.
Thank you.
Any other discussion on the motion? So I guess I now have a question. I'm sorry. I thought we were leaving in a general good cause exception, but just with a 48-hour notice requirement. Am I misapprehending the purpose of the bill?
And Chair James Orchel, Senate 21, maybe the amendment's not written as clearly as it should be, my conceptual amendment, but my intent is not to leave a general good cause exception, but to have those exceptions be related here if there's some reason that it wouldn't be within that 48 hours. And if you want, I could try to clarify the amendment if you want, or work on a mock-up if you want to try to bring more clarity to it.
That's okay. I appreciate your response. Okay, any further discussion on the motion? All in favor, aye. Aye. Any opposed, nay? Okay. We have unanimously voted to amend and do pass SB 341. And I will assign the floor statement to Senator Orenshaw. And that takes us to SB 346.
Senate Bill 346 revises provisions, makes various changes related to guardianship. This was sponsored by Senator Scheibel, heard on March 25th. The bill requires a petition for the appointment of a guardian to contain an attestation that information on supported decision-making agreements has been provided to the proposed protected person. In addition to other provisions, the bill also requires that a licensed physician complete an assessment of the needs of a proposed protected person, include a determination of whether the person is unable to understand the nature and effect of a supported decision-making agreement. And we do have one amendment proposed for this bill that was proposed by the chair, and you can take a look at that starting on the next page. This amendment proposes to amend the bill to add a definition for less restricted alternatives to guardianships, which would include supported decision-making agreement and power of attorney for financial matters and durable power of attorney for healthcare decisions. The amendment also requires a petition to transfer jurisdiction of a guardianship or conservatorship to the state to contain evidence showing that a supported decision-making was considered and include an explanation as to why a supported decision-making agreement is not reasonable alternative to guardianship. And additionally, the amendment requires a protected person coming from another state to be educated on supported decision-making agreements and, if applicable, be provided the opportunity to enter into a supported decision-making agreement. And I did want to note that there's one change to the amendment, and that would apply the definition of less restricted alternative to guardianships to Section 7 to make that applicable to folks that are coming from other states and provide them the opportunity to regarding less restrictive alternatives to guardianships. And I believe the chair, if she can provide anything, this is her amendment. Thank you.
Thank you. Any questions on SB 346 or the amendment? Okay, then. I would accept a motion to amend and do pass.
Move to amend and do pass, Chair.
All right. We have a motion from Senator Orenshaw. We have a second from Senator Wynn. Any discussion on the motion? Okay. All in favor say aye. Aye. Any opposed, nay? All right. We unanimously vote to amend and do pass SB 346. I will assign the floor statement to myself, and that takes us to SB 406.
Senate Bill 406 revises provisions related to civil liability. This was sponsored by the Senate Committee on Judiciary and heard on April 1st. The bill provides that the state, any university, college, or community college which is part of the Nevada system of higher education, and the officer or employee thereof are immune from civil liability for any damages sustained as a result of certain acts or omissions of the state, institution, or higher education officer or employee in response to or on the basis of the public health crisis caused by the coronavirus disease of 2019. We do have one amendment proposed by ENSHI, and you can take a look at that on the next page. The amendment clarifies that gubernatorial directives may be good faith subject of ENSHI compliance, aligns the definition of institution of higher education with NRS 396, and provides a legislative declaration regarding the compelling state interest. Thank you, Chair.
Thank you, Mr. McDonald. Any questions on SB 406? All right, I don't see any questions. I would accept a motion to amend and do pass. We have a motion from Senator Lang and a second from Senator Wynn. Any discussion on the motion? Senator Krasner.
Thank you, Chair. I just still have some concerns with the bill. As a general policy issue, I really don't like taking citizens' right away from them to sue someone in a civil manner and receive money damages. So I am going to be voting no on this. Thank you.
All right, any other discussion on the motion? Not seeing any. All in favor say aye. Aye. Any opposed, nay. The sole nay from Senator Krasner. Otherwise, the motion does pass to amend and do pass SB 406. And I will assign the floor statement to Senator Wynn. That, I believe, concludes our work session for today and brings us to our bill hearing for this afternoon. I will now open the hearing on SB 350.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. For the record, James Orenshall. I represent State Senate District 21 down in southern Nevada. Thank you for hearing Senate Bill 350. With your permission, Chair Scheibel, I'd like to turn it over to my co-presenter, David Anthony. He's an attorney in Las Vegas, Nevada, who specializes in capital cases. I'd like to ask him to walk us through the bill. There is an amendment I submitted, which makes a clarification. There was some concern that there might be some ambiguity in the language of the bill, so I did submit an amendment to clarify one point in the bill. So I would ask the committee to look to that amendment on Nellis, and then I'm happy to answer any questions. But if I could turn it over with your permission, Chair, to Mr. Anthony.
Absolutely. Thank you, Senator Orenshall. Please go ahead, Mr. Anthony.
Good afternoon, Chair Scheibel. My name is David Anthony, D-A-V-I-D. Anthony. I am a public defense attorney, and I am testifying and presenting SB 350 today in my personal capacity. SB 350 revises timelines for the time period between the signing of an execution warrant and the date specified for an execution. Section 1 of the bill concerns NRS 176.345. Currently, the time frame specified in the statute is between 60 and 90 days from the date that an execution warrant is signed to the execution. The proposed legislation would increase the time period from 180 to 270 days. Similarly, in Section 2 of the proposed legislation, it would amend NRS 176.495. Currently, the time frame in that provision is not less than 15 days nor more than 30 days. And the legislation would increase the time period in that statutory provision from 180 to 270 days. The legislation would also ensure that there is only one execution warrant that would be pending in Nevada at any given time. That's the accept language at the bottom of both Section 1 and Section 2. And in reference to Senator Orenshall and the proposed amendment is not a substantive change, only to clarify that there would only be one pending execution warrant at any given time in the state of Nevada. I think that there are a lot of benefits from the proposed legislation. Primarily, I think this legislation represents a common sense reform that helps bring the law into conformity with what the actual practice is in litigating capital cases that are facing an execution warrant. It's also a way to reliably adjudicate legal issues that arise at the when an execution warrant is pending that would need to be litigated anyway, and this time frame allows those important issues to be adjudicated in a reliable manner. As a practical matter, the primary provision that governs execution warrants is the Section 495. The reason that 345 doesn't come into play is because in Nevada there's also a statute that requires and provides for a mandatory right to a direct appeal, whether the defendant wishes to waive the appeal or not. So as a practical matter, the section in 345 is stayed as a matter of course. The more concerning provision is the provision in section 495, and that's the provision that normally applies when there is litigation concerning an execution warrant. That time frame, as the committee can see, is a time frame that's limited to 3 weeks. And I believe that the proposed legislation would be beneficial from the perspective of all of the stakeholders that are involved in the process. The stakeholders being the Nevada Department of Corrections, the capital defendant, the state, and the family members of the victim. The other thing that the proposed legislation remedies is it avoids the problem of having multiple execution warrants that are pending in different jurisdictions. In Nevada, unlike other states, an execution warrant is issued by the district judge in the county where the conviction occurred. In many other states, execution warrants are issued by a single entity. And so there's always an awareness of what execution warrants are outstanding, and there's never a situation where you have overlapping execution warrants with the problems that that entails from a logistical and a legal perspective. The other thing that I think is important about the legislation that I want to talk more about is I think that it has a way to avoid certain types of litigation that are actually occurring now. And I'll talk more about that, but I'm primarily concerned with the issues about procedural due process, because when you have a 3-week time frame, there's certain types of litigation that will occur no matter what. Obviously, there is an appeal process that precedes the issuance of an execution warrant, but there are certain constitutional rights that cannot be litigated until there is an execution warrant. Otherwise, those issues are not ripe. And so I want to talk more about those, but I also wanted to talk about the stakeholders involved, starting with the Nevada Department of Corrections. One of the things the proposed legislation does is it ensures that there is sufficient time by the department to prepare and to effectuate an execution in a manner that complies with the execution protocol that the Department of Corrections currently uses. I submitted a copy of the current NDOC execution protocol as an exhibit to this hearing. One of the things that folks will note looking at that protocol is that it has certain things that have to occur on or before 30 days before an execution. There are requirements about contracting, about having available EMTs, arranging for the attendance of an attending physician, arranging with the county coroner's office, making arrangements with the inmate spiritual advisor, as well as the prison chaplain. The execution protocol also contemplates that there would be rehearsals that would take place moving in the time frame from 30 days before the execution all the way up till the execution itself. In prior litigation, the former director of the Department of Corrections, Director Daniels, testified about the significant costs that are involved in preparing for an execution. Former Director Daniels talked about the need for bringing NDOC staff from other institutions to take care of matters concerning security, and also to ensure that the test runs both for the security protocols and for the execution process are rehearsed in preparation for an execution. Ultimately, former Director Daniels testified that, in his opinion, 90 to 120 days would be the time frame that he would prefer when it came to fashioning the execution protocol and also making sure that adequate preparations were made for the execution. Similarly, I had talked a moment ago about the types of litigation that occurs in capital cases. There are certain constitutional issues that cannot be litigated earlier and that are only ripe once there is an execution warrant. The different types of litigation are varied, but the primary parts that I wanted to mention to the committee are the parts governing the right to be competent for execution, also the ability to seek a commutation of the death sentence from the pardons board, and finally to have an opportunity to litigate the method of execution. So looking at those different rights, one of the things that occurs whenever there's a short 3-week time frame is there's always a procedural due process issue that's always being litigated in connection with the constitutional right that is sought to be protected. And so if the committee looks at what the current statutory requirements are, you can see the difficulties involved in successfully conducting all of that litigation in a very focused, expedited 3-week time frame. So for example, with the issue of competency to be executed, the district court is required to appoint 2 experts to conduct an evaluation of the defendant for competency. They have to submit their reports. There would often be a contested evidentiary hearing. There would be findings of fact by the court, and then there would also potentially be an appeal from whatever determination was made by the district court. It is very, very difficult to be able to reliably litigate an issue such as competency to be executed in such a compressed time frame. What it often means is that there has to be an initial piece of stay litigation just on the issue of whether the defendant will receive procedural due process to even be able to litigate that issue. And then there's also the issue of appeals to the Nevada Supreme Court if necessary. All of those important steps, as a practical matter, don't occur within the 3-week process that's set forth in the current statute. Similarly, with the issue of the Pardons Board, the Pardons Board currently meets quarterly, and the difficulty faced by a capital defendant is that it would be a very rare situation where the defendant would be able to submit an application that could be voted on to be put onto the Pardons Board meeting agenda within the 3 weeks that exist for obtaining a stay of execution. Similarly, we've had issues with litigating the method of execution. Today, the Department of Corrections is using a new and novel protocol, and when that issue was originally litigated in federal court, what ended up happening is the federal court issued a preliminary injunction just to give an opportunity to litigate that important issue. And so for all of those reasons, I think that the stakeholders that are involved here, whether we're talking about the Department of Corrections, whether we're talking about the capital defendant, whether we're talking about the state or the victim's family, I think that each of those stakeholders would benefit from the legislation, because in the status quo right now, what happens is there's multiple stops and starts, and that can cause a lot of difficulty when it comes to the costs involved with the department for preparing for an execution. And it can also be a significant factor for victims and victims' families who are informed of a date, just to have the date stayed and to have another date set. And so I believe that the legislation before the committee would remedy a lot of those problems and ensure that all of the different interests of the different stakeholders are adequately represented. And ultimately, I think that a piece of the litigation that occurs in all of these cases concerning the ability to get notice and an opportunity to be heard, I think that that type of litigation could be ameliorated if we were able to extend the time frame between the issuance of an execution warrant and the execution itself. It would ensure that that stop-start process that currently occurs, that wouldn't it wouldn't be as much of a significant factor. And just in closing, there's so many valuable rights that have to be vindicated and can't be done until there is an execution warrant. It's important that those rights receive the same protection and the same reliable determination as the rights that are litigated in prior proceedings. And so for those reasons, I would ask the committee to consider and to approve SB 350, and I'm certainly available to answer any questions that the committee members have.
Thank you so much. Members of the committee, are there questions on this bill? Senator Ellison.
Thank you, Madam Chairman. I do have a question. From the day of finding the prisoner guilty till the day of the execution, how many years is that?
This is David Anthony for the record. Senator, I think that the length of time varies. I know that historically there were longer time frames that I believe have been tightened up considerably. So it would be hard for me to give the committee a one-size-fits-all answer. I've seen, some lapses of time that are, maybe more around the area between 6 to 8 years. And for older cases, it could be a significantly longer period of time, just based on different considerations like statute of limitations issues.
Follow up, Madam Chair. Well, and when you go through all these processes and how much money it costs and whatever, but my biggest saying is the families. The families have to live through this over and over and over and over. And they're the ones that's alive and suffering. And I just think that they've got to be a way to condense this to where they can get these trials done and the hearings done and all the different boards and whatever. But I think that at the end of the day, that the people that are suffering is the families.
Chair Scheibel, James Ornshaw, Senate District 21, through you to Senator Ellison. Certainly from my conversations with Mr. Anthony, who's an expert in this area, been practicing in this area for many years, I believe that this extension of time here in SB 350 will lead to less litigation. And I think certainly he expounded on that in his presentation. He can probably give more specifics, but I believe it actually can lead to less litigation.
And this is David Anthony for the record, responding to the question and comment by the senator. Yes, I do think that the proposed legislation in a way can actually cut down on certain types of litigation, because getting back to what the different issues are when a person is facing execution, there are certain issues that would need to be litigated no matter what. And so providing a reasonable time frame for those things to be litigated, I think makes a lot of sense. And I think it also makes a lot of sense from the perspective of the state's interest in finality and also the victim's interest in having a predictable date for an execution itself. One of the pieces of litigation that would be obviated, I believe, to a substantial degree are the issues about procedural due process and about notice and an opportunity to be heard. With this longer time frame, those considerations wouldn't be as pronounced, and it could, I think, lead to a more reliable determination by the court about whether a defendant is competent to be executed, whether the defendant should have the opportunity to present his case to the pardons board, or whether there is a valid challenge to the method of execution. I think for those reasons, I believe the proposed legislation could actually decrease some of the litigation that's occurring now and could actually lead to more reliable and predictable outcomes.
Did you still have a follow-up, Senator Ellison? Go ahead.
I just had one other thing, and does it depend on the age of the individual that was the victim, you know, like a young child versus somebody that's, you know, up farther in age? Does that make any difference whatsoever?
Senator, this is David Anthony for the record. The proposed legislation would present the same uniform timeframes for any person, regardless of what the characteristics of the victim in the case were. So the legislation would be uniform. However, if we're talking about the age of the defendant, which is certainly an issue on Nevada's death row with an aging population, that does present special challenges when it comes to issues like competency for execution and also for method of execution challenges, because that could affect things like access to peripheral veins for lethal injection. So there are individual characteristics, at least for the defendant, that would need to be litigated anyway. But as far as the characteristics of the victim, the legislation would be uniform and would afford every capital defendant the same opportunities once an execution warrant was issued.
Thank you. Other questions? Senator Hansen, go ahead.
Thanks, Madam Chair. Last execution we had in Nevada was 2006, we just looked up. How often do we actually have the type of litigation that you guys are mentioning? Is that something that just comes up frequently? I mean, the guy that was killed in 2006 actually requested the death sentence, so I'm kind of wondering how often does this situation come up where you guys have to litigate on all these issues?
This is David Anthony for the record. In my experience, there has been what I would call end-stage litigation that's been occurring in a handful of cases going back to 2017. So while, Senator, you're correct about when we had the last execution, which was in 2006, more recently, there has been this type of litigation concerning the method of execution and other issues. And one thing that I would just add is that because the last execution in Nevada did occur in 2006, I think that's another reason why affording the Department of Corrections the time they need to prepare is also very important, is because it's not a process that the department has had to do recently. So I hope that that answers your question, Senator, but that's my understanding.
Thank you. That answers that question. I mean, ever since the DeMarlo Berry situation, I've had, frankly, my confidence shaken a little bit on death penalty stuff. Big death penalty advocate, mainly because of the deterrent value of it. You know, we want to, if somebody's doing a premeditated murder or contemplating it, I would like to think that the death penalty would still act as a deterrent. But when you drag it out for 20 or 30 years, I think it loses its deterrent. So it doesn't sound like this is intending just to drag it out, but rather to give you a window of time that actually, according to your testimony, will reduce the amount of litigation if we ever do reach a situation in Nevada again where we actually start executing people on death row. Is that the intent?
Thank you. Chair, James Orenshaw, State Senate District 21, through you to Senator Hansen.
You can go direct.
Thank you. And Senator
Can't break
Hansen,
himself of that habit.
thank you. And Senator Hansen, as you know from the years we've served together, from chairing the Assembly Judiciary Committee, capital punishment is the ultimate, most severe punishment the state can impose. And certainly, as we saw in Mr. Berry's case and what happened there, where the wrong person was convicted, there have to be protections to make sure that we have the right person, that there's competency. If there's potentially a opportunity that the pardon board might consider a pardon or a sentence commutation, for that to be considered. I believe this bill, if enacted, by extending this time here, would potentially lead to less litigation. I think that's certainly the testimony from Mr. Anthony. I personally don't support the death penalty, and I've sponsored bills in the past to abolish it. This is not an abolition bill. This is a bill that is based on the premise that we do have the death penalty in Nevada, but here the attorneys, the stakeholders, need to have the time to litigate these issues. Hopefully at the front end, they'll lead to less litigation further down the road. That's my opinion. And if Mr. Anthony, feel free to chime in if there's anything else you'd like to mention.
This is David Anthony for the record. Picking up on the case that the senator mentioned, the DeMarlo Berry case, I think it's also worth noting that the DeMarlo Berry case was originally tried as a capital case. And in the DeMarlo Berry case, the evidence of innocence was only produced several years later. It wasn't produced until an inmate in a California prison facility converted to being a Jehovah's Witness and decided that he needed to get something off of his chest. And that's when he came forward and confessed to be the actual killer. So I do think that the situation with DeMarlo Berry really highlights what the need is to make sure these issues are reliably sorted out. Nevada does have a procedure for presenting evidence of factual innocence and genetic marker analysis, such as DNA testing, and those provisions are also ones that I haven't mentioned yet, but those could also be implicated in the timeframes that we're talking about with the legislation. And so I do agree. I think that the DeMarlo Berry case is a paradigmatic case that really highlights the importance of getting things done right in a reliable manner, even if they occur several years after a conviction.
All right, well, thank you. That was very well answered. But here's a question I do have, and this may be for legal. Once an individual is convicted of a capital offense and he has been assigned to be killed, are there people that are currently on death row that haven't had their full? Right now, are there people that, if a governor was willing to move it forward, would they be executed like within the 120 days or whatever that this bill has, or is there still people that are on death row that have elements that haven't been fully litigated before possibly facing execution? It sounds like we're almost talking like there's, all these people that are sitting there on death row that have all this litigation still to go. Does that only kick in if, who actually is the one that says, we're going to execute this guy? Is it the governor? Is it, how does that work in the justice system? I don't really know.
And Chair, James Orenshaw, State Senate District 21. I don't have the exact number of persons on death row right now. I'm not sure, Mr. Anthony, if that's any information you have or what in terms of Senator Hansen's question, but I wonder if I could defer to Mr. Anthony, Chair. Thank you.
Thank you. This is David Anthony for the record. My understanding, and I want to make sure I'm accurate as possible, but I believe there's approximately 60 individuals on Nevada's death row who are in various stages of litigation. To answer the senator's question about what the triggering event is, usually the triggering event is once the defendant has completed one full round of litigation in state and federal court. What usually is the marker is when the United States Supreme Court denies certiorari after the defendant files a first federal habeas petition. So I couldn't give precise time periods for each defendant about where they are in the process, but that's usually the marker for when the litigation is considered, concluded, and that allows the local district attorney's office in the county where the conviction occurred to go file an application with the district court and to seek a warrant. So that's usually the normal process.
Okay, thank you. No, this is way off the bill's topic, I think, so, but I would like to talk to you more about the actual procedure, because I know the governor ultimately has the ability to basically say no, but he doesn't have the ability to say yes, apparently. That is actually something that goes to the United States Supreme Court. But anyway, I'm sorry, I would like to learn more about that, but I don't think it's something the entire committee needs to be drug into. Thank you, Madam Chair.
Thank you, Senator. I think Senator Krasner had a question. Go ahead.
Thank you, Chair. So this has brought up several questions, and I think my question is for Mr. Anthony, if that's okay. So what we're looking at here is when the judgment of death is pronounced, how many days are going to be given after that? So it currently is, 60 to 90? And we want to extend it to 180 to 270. And so what happens before this judgment of death? Is there a jury trial? Are there some hearings? Are there some appeals? I mean, is this a sudden thing, or is there many trials and appeals before this? What does that look like? Like, say, once the person is arrested, what happens after that? And before this judgment of death, please. Thank you.
This is David Anthony for the record. Senator Krasner, I think that the provision that you referenced was the provision in Section 345. If you want to go back to the time of arrest, at that point, there's the charging process, and normally a capital case is set for trial within, I would say the average is around 18 months or so from initial appearance. And again, this is just an estimation. It could be longer or shorter for specific reasons. The provision that the senator references occurs after the jury has rendered a verdict of guilt, and then they have rendered a penalty verdict. A jury in Nevada is required to designate statutory aggravating circumstances that are found beyond a reasonable doubt. They're required to weigh those circumstances against mitigation, and based on their own moral judgment and their bringing the conscience of the community to bear, then they render a sentence. And so once that verdict is received by the trial court, that's the point where the process that the senator was referring to, that's when it occurs. That's when the 60 to 90 day time period occurs. Now, as I mentioned earlier, as a practical matter, that's more pro forma, because in capital cases, there's a mandatory right to a direct appeal, because the Nevada Supreme Court reviews all capital cases to determine whether there's evidence of aggravating circumstances and whether the sentence was the result of passion and prejudice. And so for those reasons, the provision that the senator was referencing are normally always stayed. So that doesn't necessarily come into play. The more problematic provision, and the one that I wanted to highlight in the course of this discussion, is the provision in Section 495. And that's the one that provides for a mere 3 weeks as opposed to the 60 to 90 days. But hopefully that was that answered the senator's question about where the 60 to 90 day warrant, where it fits in the process.
Thank you.
All right. Any further questions from members of the committee? I am not seeing any, so thank you for your presentation and for sitting through with us and answering all of those questions. At this time, we will move into testimony. I will start with testimony in support of SB 350 in person, either here in Carson City or down south in Las Vegas. If you wish to give in-person support testimony, now is the time to come on forward. I think you all have been here before. You know the rules. Give us your name and spelling. Keep it to approximately 2 minutes, and go ahead whenever you're ready.
Good afternoon, Chair and members of the committee. My name is Kayla Maese, spelled Kaylah. Last name is Maese. I'm a civil rights analyst at the ACLU of Nevada. The ACLU of Nevada strongly supports SB 350 as it introduces necessary reforms to Nevada's death penalty process by extending the timeline for execution warrants. What this bill does is that it ensures that individuals who are facing the ultimate civil liberties violation affected by the government have additional time to conduct a legal review and ensure that the state of Nevada is not simply rushing to kill its own citizens. We urge the committee to support this bill as well. Thank you.
Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. We did all the previous comments and want to thank the presenters and Senator Orenshaw for bringing this very, this piece of bill to you. We have talked about the DeMarlo Berry case, in which being an innocent man, and we know that as the people get older, the real perpetrators of the crimes, they're starting to confess, and thereby exonerating individuals who are sitting on death row and in prison. We have submitted 5 exhibits, or an exhibit with 5 photographs, I would like for you to take a look at. One is dealing with the ghost walk that I attended, and I took with my phone, and I captured orbs, and actually inside the death chamber, the gas chamber, there are photographs of what I call the lost souls of individuals, and a man, you can actually see his face. And I believe, personally, I believe he's an innocent man, and maybe that is why I was the only one who ever was able to capture this, and I would like you to take a look at that as well. And again, with it costs over $1 million to execute an individual. By extending this, I do believe it will lessen that on the taxpayer. And we want to afford the opportunity for any innocent person on death row to have that extra time in case genealogy, forensic genealogy, DNA can provide an exoneration. That is possible. Any kind of future DNA that could exonerate these individuals and give them the opportunity to at least try to get as much out there as they can to clear their names before they're executed. Thank you.
All right. Thank you, Chair, members of the Judiciary Committee. My name is Harrison Epstein, Harrison Epstein. I'm a legal extern with the Clark County Public Defender's Office. We support wholeheartedly extending the time for which a judgment of death must be executed. It is essential that every person facing the death penalty is afforded every opportunity for a thorough and fair legal review. This extension is one step to help ensure that any additional legal challenges, appeals, or new evidence can be fully considered to avoid the irreversible mistake of executing an innocent person. Given the gravity of the death penalty and the profound consequences of any error, it is crucial that all appropriate measures are taken. Thank you.
I'm not sure if anybody else is coming forward in Las Vegas. We do have one more in Las Vegas. Come on down.
Yeah, we have two.
Sorry.
We have 2 of us down here. I think it's okay. We were trying to be respectful.
Nope, I
Good
confused
afternoon.
my geography. Go ahead in Las Vegas, then we'll come back to Carson City. Go ahead.
Oh, I'm so sorry. So good afternoon, members of the committee. My name is Mark Bettencourt, MarkBettencourt. I'm here as the executive director of the Nevada Coalition Against the Death Penalty. And I'm here on behalf of the organization and our members to support SB 350 and humbly ask that you all do the same. It's no surprise that the Nevada Coalition Against the Death Penalty seeks to end Nevada's death penalty because we see that data and research show that it is biased, it wastes taxpayer money, and to Senator Hansen's point, we actually show that it does not have a deterrent effect on crime. And when surveys of law enforcement have been done, those folks have considered the death penalty very, very low on the list as a deterrent effect. And research has shown, in fact, the opposite, that jurisdictions that maintain the death penalty have higher rates of violent crime that those then don't. Now, despite that being our ultimate goal, I want to say that SB 350 is a smart piece of policy. It will bring the existing execution process in line with the reality of these cases and allow for adequate preparation to be carried out by NDOC and its staff, and also for them to process the role they may play in the potential taking of another person's life. Not to mention, as the presenters have said, that this bill, or excuse me, that an execution hasn't taken place in nearly 20 years. We also believe that this bill creates some greater transparency for all stakeholders involved and will help ensure fairness for everyone. And it will prevent the start and stop process and the uncertainty that goes along with it for all of those folks impacted by this that ultimately can go on indefinitely. This bill is a far cry from ending the death penalty, but it is a smart, common sense update to the law that should ultimately save the state money. Thank you all.
Good afternoon, Chair and members of the committee. My name is Sue Birch, S-U-E-B-U-R-T-C-H. I am the Executive Director of the Nevada chapter of the National Organization for Women. For the sake of fairness, we completely support SB 350 and we urge you to pass it. Thank you for your time.
All right, now I actually don't see anybody else coming forward in Las Vegas, but we do have one more person here in Carson City to give in-person support testimony. Please, sir, go ahead. I think you have to turn the microphone on. There's a little button, it looks like a sticker on top of the desk, and it'll turn bright red.
Got you. Okay. My name is James Allen, and I thank you for this opportunity. You're looking at a former death row inmate here in the state of Nevada. When the death penalty was reinstated in the state of Nevada, I was the first young man to receive it, 1981. I was one of the young men, one of the youngest guys sitting on Nevada's death row. And a lot of people paid a lot of interest in my case because I was a young, stupid, ignorant kid with a gun. And I took an innocent life. But people saw the good in me, and they sought after me from death row. I mean, from school teachers right here from Reno, Washoe County to Clark County. And they got interested in this young black kid sitting on Nevada's death row. My first execution date was within 40 days of my sentence. I was supposed to be executed on my 20th birthday, November 16th, a day after my birthday. So I wasn't going to make that birthday. But I'm here today in support of this SB 350 bill because my attorney at the time, he was begging the state, he was begging the courts and everybody, let me give James the adequate counseling that he needs. He's sitting on death row. He's an ignorant kid. He doesn't have an education. He's done something awful. He knows he's did something wrong. And people got involved. But they gave my attorney that opportunity to show who I really was and the possibilities. I'm 65 years old now. I'm not that 18-year-old kid. I was allowed to go back to Nevada State Prison, which they has opened it up for a tourist attraction. And I wanted to go back in and go back on death row at this age, and they allowed me to do that. In going back in to that prison, it was an eerie feeling. And I took a picture of me standing in the chamber, which I never had a chance to step in, look at, or anything. You know, I was one of the guys that they didn't put in an overnight cell, and you know, you're gonna see the chaplain, you're gonna see your family, and what special meal do you want? You know, there was an execution while I was there, and I tell you, no one has the right to take anyone's life. We all are human beings. We're all part of this big race. And I have been given a second chance. And I talk to youngsters, kids, I talk to everybody. And I try and let them know capital punishment, man. I'm free. I was given the opportunity to live my life. My victim, oh, if I can bring that guy back. But I wanted to be here today in support of this bill because I understand the lawyers, because as a young kid whose mind is not developed, he don't know what he's getting into. She don't know what they're getting into until those handcuffs are on you and you're placed behind bars, and now you're faced with a situation that no one told you about. You know, you're out here doing all this crime and doing all this wrong, but the attorneys have to go through so much and they know you're guilty. That's the first thing an attorney asks you. They're seeking the death penalty on you. Did you do it? And I said, yes, sir, I did it. I am guilty of taking a person's life. And then he made me understand that they gave you the death penalty because a 12-member jury understood the seriousness of this crime. I wasn't developed yet. I didn't know what was, an execution is something it lingers. I heard somebody on the panel say it stays with the family. It stays with the victim. I was allowed to talk to my victim's mother, and she gave me that embrace. Go out and make something of yourself. They want to let you out. They did all the litigation. The attorneys did what he had to do. And now, James, the parole board is going to give you a chance to go home. Get an education. I walked out of there with a GED and a high school diploma and an associate degree from death row. I served 30 years, and my attorney is still around, and I thank him for that. I thank him every day. My mom was a community activist, and she fought hard, and she had the opportunity to see me come off of death row. And now I'm in Clark County, the Vegas area, and I give back every day. The attorneys call me to talk to people who are facing capital punishment in jail. I get to go in and talk to these young people and let them know, hey, you may not get what I got because it's an individual thing, but they're seeking the death penalty on you. Do you know what you did? And we can't save everybody. The death penalty was put in place. Some cases are different than, it just made me realize I was the 12th person in 1981. And they called me a disciple because I didn't understand Christianity. You're the 12th disciple. I'm the 12th disciple, but yet they're going to put me in a gas chamber. So going back and looking at this chamber and these two chairs sitting in this chamber and how the method of execution, which was gas at the time, and I was supposed to choke and not breathe and die in the chair. And my attorney made that so clear. And an attorney, there are some of the most important people. When you're dealing with capital punishment, you know that there's life without the possibility of parole and there's the death sentence. And I know that there were legislation at the time. If an inmate made it off of death row, he will never see the outside again because he was sentenced to die. He had capital punishment. Well, we know that's not true. I've had governors, directors. I even had Senator Reid, Senator Harry Reid. I hate to drop names, but got involved with me. He saw something in me, and he embraced me when I came home. I've never had anyone with power like that give me such a powerful hug and say, go out, young man, do something with your life. Because in my mind, I was supposed to be 65 years old, still sitting in prison. I took a life. You don't take a life. We're precious, man. You don't do that. And I put it out there so vaguely and so strongly today, that I walk around and it feels like I'm in a space all by myself because you don't hear about these stories, guys coming from death row, from 30 years of prison, and I'm guilty. I took the life, and I'm walking around free. It bugs me every day that I was given this opportunity. I don't know what else I can say to convince you to pass this bill push it through. But remember my name, because I'm going to be speaking out. There's guys, and they're guilty. They're guilty, but there has to be an easy method. There has to be another way where we can do this like human beings and be civil with each other. Crime is going to be here. It ain't going anywhere. These youngsters are getting smarter. This technology is, when I came home, I hated this thing, but, and I'm still a dinosaur. A lot of time was taken away. I stand out here amongst college people and people who are smart, and they look at me like I'm the smart one. I go, no, I want what you got. I want that book knowledge. I want that degree. I want, I want that career. But at this age, I understand. I'm here to be a servant, and I'm going to serve. Whoever needs James Allen's story, you need me to talk, you need me to come and do whatever, stand on my head, I'm here. Thank you for this opportunity. And this SB Bill 350, it's important. It's important to us. Thank you.
Well, thank you so much for sharing your story with us and for being here today to give testimony. We appreciate it. We appreciate input from everybody who takes time out of their day to share with us in testimony and in public comment. So with that, I will wrap up in-person support testimony on SB 350. We will go to the phones for support testimony on SB 350.
Thank you, Chair. If you would like to testify in support of Senate Bill 350, please press *9 now on your phone to take your place in the queue.
Hello, dear members of the committee. My name is Yesenia Moya, Yesenia Moya. I'm here in strong support of SB 350. I just want to say ditto to everything that was said. We need to ensure that no decision over a human life is ever rushed. People on death row are not abstract statistics. They are sons, daughters, parents, and members of our community, and many have endured so much trauma and systemic failures long before they even enter the criminal legal system. They deserve fairness, dignity, and the full opportunity to have their cases really looked at. It is a common sense policy that ensures transparency, fairness, and due process and allows time for litigation to be completed. So it does so, we need to have the highest level of scrutiny and responsibility over human lives. I urge you to support this bill and prevent the devastating consequences of a rushed and reckless process. Thank you.
Good afternoon, Chair Scheibel and members of the committee. My name is Denise Bolaños Heredia, Bolanosheredia, and I'm the Associate Director of Return Strong, an organization dedicated to advocating for incarcerated individuals and their families in Nevada. Return Strong firmly opposes the death penalty due to its inherent flaws, including the risk of executing innocent people. Since 1973, over 190 individuals sentenced to death in the U.S. have been exonerated, according to the Nonpartisan Death Penalty Information Center, which provides fact-based research and analysis relied upon by policymakers across the political spectrum. SB 350 does not fix the fundamental problems with the death penalty, but it does acknowledge the critical need for additional time to prevent irreversible mistakes. This bill recognizes that our legal system gets it wrong far too often. The risk of executing an innocent person is unacceptable, and any measure that allows for a more thorough review of these cases is necessary. The notion of an eye for an eye may seem like justice to some, but as history and experience have shown, it ultimately leaves the whole world blind. True justice demands caution, fairness, and the opportunity to correct mistakes before it's too late. Mr. Allen, congratulations on your second chance at life, and thank you for sharing your story. We urge you to support SB 350.
If you've recently joined us and you would like to testify in support of Senate Bill 350, please press *9 now on your phone to take your place in the queue.
Hello, Chairwoman Scheibel and members of the Judiciary Committee. My name is Shaylin Dieter, Shaelyn Dieter. I'm an attorney in Las Vegas, Nevada, and a steering committee member of the Nevada chapter of the National Lawyers Guild and Nevada Attorneys for Criminal Justice. We are here in support of Senate Bill 350. Though, to be clear, our members believe that the death penalty should be abolished in its entirety. This bill does fall woefully short of abolition, but we agree that the current timeframes under which the to effect an execution in Nevada are themselves woefully short. These current timeframes do not allow for a full and fair consideration of the myriad of issues raised by an execution. If Nevada insists in tinkering with the machinery of death, it should certainly allow for reasonable time for such tinkering to occur. With unabashed disapproval of the death penalty in Nevada, the National Lawyers Guild nonetheless urges this committee to pass Senate Bill 350. Thank you.
Hello, my name is Amelia Castillo, Castillo, and I'm also in support. I know it was mentioned that the last execution took place in 2006, but in 2007, my loved one joined the list of volunteers who gave up his appeals and wanted to be executed. 80 or 90 minutes before his execution, and to his disappointment at the time, he was granted a stay due to the intervention on his behalf by the ACLU. My loved one has been on death row for nearly 30 years and is still going through the appeals process. The death penalty is a very slow, expensive, and ineffective sentence handed down mostly to those who are economically disadvantaged, and many are under the age of 25 at the time they were arrested. If the proposed changes in this timeline was effective back then, maybe the stay would have come before he'd eaten his final meal and he said his goodbyes. Maybe it would have come before the added expense the state had to incur to coordinate and carry out his execution, as well as the trauma caused to the victim's family who traveled to the prison only to be told it was canceled. Maybe it would come before his death certificate was signed, which, just so you know, is a very difficult thing to get corrected from death row. There are legitimate logistic issues that arise, and these additional days could allow sufficient time to address them. Thank you so much for your time and consideration.
Good afternoon. I'm here today in support of SB 350, and I urge you to do the same. This is a common sense reform that acknowledges the reality of capital punishment in Nevada, one plagued by errors, logistical failures, and immense financial burden on taxpayers. It's hard to put into just 2 minutes how deeply important this issue is. I have never supported state-sanctioned killing, and let's be honest, that's what the death penalty is. But I have to admit, I didn't fully understand the weight of it until it affected me personally. I have a loved one on death row. I'm here today to try to be a voice for him and the others alongside him in Nevada. I'm not here to excuse the horrific tragedies that led to their imprisonment, but we must be honest about what the death penalty is, what it was meant to do, and what it actually accomplishes. The truth is, it is ineffective. It has been proven not to deter crime, and states that execute more people do not have lower crime rates. Yet it continues to drain valuable resources while operating within a system riddled with bias and irreversible errors. I asked my loved one what he would want me to share with you all, and he said, "I'm not telling you what to say, but if I had the chance, here's what I'd say." So today I'm sharing his words with you. He said, "If I were to be executed today, people would see a man in his 40s. The state would be putting to death a boy who barely knew how to be an adult. At the time of my crime, I was struggling with deep psychological anguish, substance abuse, and had the reasoning capacity of a 10-year-old, according to a psychologist. Over 2 decades later, I'm no longer that teenage boy. I grew up in prison in an environment that fosters violence, not peace. But despite that, I've worked hard on myself mentally, spiritually, and intellectually to grow far beyond who I was on that terrible night. I take full responsibility for my actions, but I hope you all recognize that who I am today is not who I was then."
That's the end of his quote. And now I ask you to reflect, are you truly comfortable putting the teenager I just described to death, or anyone for that matter? Nevada's handling of the death penalty leaves us in a dangerous limbo. On one hand, I'm grateful my loved one is still alive, but by not taking a firm stand, Nevada allows decision makers and citizens alike to avoid confronting the uncomfortable truth. The death penalty is racially and economically biased, exorbitantly expensive, and too often driven by politics rather than justice. It's time for us to decide who we are as a state. Are we a state that clings to a broken, outdated system, or are we a state that values fairness, humanity, and justice that serves everyone? Please support SB 350, which is only a step in the right direction.
And before you go,
Thank you.
we didn't get your name at the beginning of your testimony.
Oh my God, I'm so sorry. Ashley Shedd, Shead.
Thank you.
Thank you.
Yes, good afternoon. My name is Ryan Sanchuk, Ryan, last name Sanshuk. I'm a disabled veteran, and I'm also a volunteer for the Nevada Coalition Against the Death Penalty. I just want to bring it to everybody's attention, the case of Scott Dozier, an inmate, a death row inmate who volunteered to be executed. He sent out a letter to a judge in October of 2016 wanting to waive his appeals to be executed, and he also, made it known to the Nevada Department of Corrections that he wanted to be executed. He didn't want to live anymore. It was too harsh to remain on death row, and he wanted to be executed as such. The process took about 2.5 years, and the Nevada Department of Correction didn't do anything. They didn't do anything to set up to execute Mr. Dozier. And his mental health deteriorated to a point to where he ultimately took his own life in his cell, and he didn't. And it was just a scandalous affair. The fact that he wanted to be executed, and he wanted to die, and he ultimately committed suicide, just really illustrates that Nevada logistically is not prepared to resume executions. Now, with SB 350, this would help Nevada streamline the process. If there were to resume executions, this would give ample amount of time to make sure that they get the protocol right. So from a logistical point of view for Nevada Department of Corrections, this bill actually helps NDLC to get it right when it comes to carrying out executions. Thank you.
Hello, Chair Scheibel and Judiciary Committee. My name is Carrie Sparkle. My legal name, likely for the next 4 years for safety purposes as a trans woman, is Ian Bigley. I'd like to testify in support of SB 350. The death penalty, as has been stated, is inherently an inhumane practice. However, this bill makes it more humane. No death penalty is humane. This practice can't be humane in any form. However, it allows for better due process, and it's something that, given the current reality of the death penalty in the state of Nevada, I strongly urge, as someone who was born and raised in Nevada and plans to live here for the rest of my life, I strongly urge our elected representatives to support this bill as well. I won't belabor a lot of the points that have been stated, but would like to say that I strongly support the other support testimony that has been stated. Thank you very much for your time, and I hope you have a good afternoon.
Hello, good afternoon, committee. My name is Teresa Yancey, T-H-E-R-E-S-A, last name Yancey, Y-A-N-C-Y. And I'm here to express my strong support of Senate Bill 350, a bill that extends the time for execution warrant scheduling from the 60 to 90 days to up to 270. This is not just a policy issue for me, it is deeply personal. I have a childhood friend who has been on death row for over 3 decades, and I have witnessed firsthand the immense stress, uncertainty, and the emotional turmoil that the current system imposes, not only on those sentenced, but their loved ones, the legal teams, and even correctional staff. The process of capital punishment is one of the most serious and irreversible decisions our justice system makes. Yet under the current timeline, the rushed nature of scheduling and appeals can lead to critical mistakes that we just cannot afford to make. SB 350 provides a more structured approach, allowing the courts, the attorneys, and the NDOC the time to ensure that every aspect of the process is handled with the seriousness and care that it demands. Beyond the legal and procedural concerns, there is an undeniable human toll. Families of those on death row also suffer through the unpredictability of this process as well, and the additional time granted by SB 350 would provide at least a measure of consistency, ensuring that decisions are made with deliberation rather than haste. SB 350 is not about changing the law on capital punishment. It is about ensuring that Nevada handles these cases with the utmost care and ethical consideration. Justice should never be rushed, and human lives should never be reduced to administrative deadlines. So I urge you to support SB 350 and help us create a system that reflects the gravity of the decisions that are being made. Thank you.
Thank you so much, legislators. My name is Nathaniel Phillips, and I am a resident of Reno, Nevada. Thank you to those with the conviction to bring this bill to a hearing and to those who will eventually support it in good faith. And good faith is so important because in a society prideful of our freedoms, a state-sanctioned killing is the most serious and concerning question of liberty, and it matters to all of us. But it's very personal for me. Senator Ellison spoke on how families are impacted by an unreliable execution process. Thank you for considering the people directly impacted, Senator. But let's talk about them. I am one of them, speaking to you all as a homicide survivor. If the death penalty is supposed to deter the so-called worst of crimes, which it doesn't, then surely the man who murdered my father should be put to death for shooting him in his back, the bullet ripping through his aorta in cold blood in the parking lot of a famous Nevada resort. Can you imagine yourself being in the 11th grade and taken out of 5th period English class by your principal to give you this news? And when you get back to class and your classmates ask you what happened, you tell them that your dad was shot. I remember that the shooter was only a teenager, an ugly one, I remember, with a gun. But I never for a second wanted the crushing trauma of what happened to me and my family to be used to justify a justice or what I believe is vengeance against another family. So if Nevada is going to continue the practice of capital punishment, despite our representatives, despite some of you all having passed an abolition bill previously, then it must be carried out in a way that affirms the dignity and liberty of prisoners, because that's what we believe in as a nation, that yes, even imprisoned people are entitled to their full dignity and fundamental liberties. This bill is necessary to uphold procedural due process, as the presenter rightly mentioned, and to ensure fidelity to a fair legal process, so paramount in our frenzied political climate. So again, thank you for your consideration, and to the presenters, sponsors, and the speakers who care about victim families. Thank you so much.
If you've recently joined and would like to testify in support to Senate Bill 350, please press *9 now to take your place in the queue.
Hello, everyone. Good afternoon. Cyrus Hojati, Hojjaty. I stand in support. There are reasons why I support this bill. I'd like to appreciate all the previous commentators, very eye-opening, and I sympathize with their concerns. Let me give you an example why I support this bill. Number one is false accusations. So I just feel that somebody will want to use this procedure to essentially do harm to innocent people. I don't support that. And I also believe the so-called execution process is used for double standards. And, we look at what happened, sorry to hear about the United Healthcare CEO. It was a tragic, horrible thing, but I don't believe that the suspect deserves that kind of punishment that's being pushed on him. Because, if it happened to somebody who was not famous and wealthy, the punishment would be less severe. But other than that, we appreciate the sponsor of this bill for bringing this forward. We look forward. Hopefully this will get through. Thank you so much. And I will yield my time for others to bring their ideas forward.
Thank you, Chair. The public line is open and working. There are no further callers at this time.
All right, thank you so much. We will move then to testimony in opposition to SB 350. Anybody wishing to testify in opposition in person is invited down to the front now in Carson City and Las Vegas. Please go ahead whenever you're ready.
Good afternoon, Chair Scheibel, Vice Chair Flores, and members of the committee. Jennifer Noble, JenniferNoble, testifying in opposition to Senate Bill 350 on behalf of the Nevada District Attorneys Association. I have tried to time my comments to be 2 minutes. There were a lot of good questions asked, but I want to try to answer some of them and still stay within that. I want to thank Senator Orenshaw, Mr. Anthony, and the Coalition Against the Death Penalty for meeting with me. We had a fairly lengthy meeting that was informative and respectful. I explained our concern that tripling the time frames in the bill would lead to more last-minute litigation not related to execution protocols. As an appellate prosecutor, part of my duties are to respond to filings in capital cases. I have James Biela's case, he murdered Breonna Dennison. Folks in Washoe County may recall in 2008. I had Sayosi Venisi's case until he died recently. He murdered Sergeant George Sullivan, I believe in 1998, as Sergeant Sullivan sat in a kiosk. He was hatcheted to death. And Tamir Hamilton murdered Holly Quick in 2006 in her bedroom after torturing her. I have that case as well, and we have been litigating those cases since those times. Attorneys like Mr. Anthony are very skilled. They're really good at what they do. They're dedicated to their clients. We work with them often, and they use every procedural vehicle available in both federal and state court to avoid the death warrant from becoming or remaining active. Those vehicles, before we get to the stage that this bill is trying to address, include direct appeals, multiple petitions for writ of habeas corpus. Sometimes they're 400 pages long, such as in the Tamir Hamilton case. I have that currently. It's back to district court again. Post-conviction appeals after those hearings happen, petitions for factual innocence, petitions for genetic marker analysis, and petitions for writ of certiorari to the United States Supreme Court. This is a complex legal labyrinth, and I understand the arguments about the cost of the death penalty, but I do wonder how fair it is for the architects of the labyrinth to argue that it's too long and complicated. And even when clients indicate they no longer want to appeal, such as in the Dozier case or in the Venisi case, he wanted to forgo any more state trial phase appeals, sentencing phase appeals. The federal public defenders do their job the way that they feel is most ethical, and they continue to pursue those arguments against their clients' wishes at times. Another part of my job is explaining this labyrinth to mothers who have lost children, like Carolyn Sullivan, who lost her husband George, wives who have lost their husbands, and sisters who have lost their brothers. Most of them remain very engaged, but they are understandably frustrated. Nevada's procedural landscape exacerbates this trauma. Sections 1 and 2 of the bill triple the time period between issuance of the warrant and the execution date. And while I appreciate the logistical hurdles described in the petition, and during our discussion, the proponents acknowledged candidly and to their credit that the additional time this bill provides would likely not just be used to satisfy those procedural due process considerations related to administration of the death penalty, but also to file additional successive petitions, appeals, or writs challenging the conviction itself or the sentence itself. The time to brief those matters and related appeals would go far beyond the maximum 270-day time frame articulated in this bill. And for those reasons, the NDAA is in opposition. Thank you.
And as you might have predicted, we do have a question for you if you're willing to answer one from Senator Hansen.
Thanks, Madam Chair. This is obviously a very interesting, a much broader discussion than the bill itself. The reality is we haven't had an execution since 2006. There's significant opposition to doing the death penalty at all among certain folks. The question I have is, would be better off, because the amount of time you have to spend relitigating something that's already been, you have cases where there's no argument about the person being the person that committed the crime, would be better off just eliminating the death penalty and going to a life imprisonment without possibility of parole, where they really put them away and they stay there. Because I'm kind of wondering, is there a significant deterrent factor in your mind for having the death penalty on the books, even though it hasn't been used in almost 20 years, and the last time it was used because the guy wanted to be executed, and then the amount of time you just mentioned, the amount of constant litigation, and it goes on forever. We're having a little discussion with our legal staff. Technically, you could keep this going to where you never execute these people. So I'm kind of wondering, would we be better off in the long run? And I am a proponent of the death penalty, but it never gets used. Are we wasting your time that could be used better somewhere else, and then put these people who are on death row just permanently in prison without possibility of parole, and there they sit till their dying day?
Thank you for the question, Senator Hansen. Jennifer Noble for the record. I'll answer your last question first. It is never a waste of my time to try to litigate and ensure a penalty that is carried out, that is on the books of the state of Nevada. The death penalty is legal in Nevada, and in each of those cases, 12 jurors voted unanimously to administer the death penalty. So it is never a waste of my time. In terms of being better off, I guess that depends on what you mean. And in terms of deterrence, I think there are a lot of studies that suggest there's no deterrent effect. There's other studies that suggest there is a deterrent effect. There's definitely a retributive quality to it. I was ambivalent about it at the beginning of my career, and ultimately changed my mind after I worked on some of these cases. I think good people can disagree on this issue. But I do also believe that if this legislature votes to get rid of the death penalty someday and a governor signs that the life without possibility of parole cases will take the place of this other extensive litigation. We're already seeing that. I have those cases, life without the possibility of parole or with the possibility of parole, that I not only litigate in state court with state defense attorneys or conflict attorneys, but also they go up to federal court and then they come back and then I litigate them again with the federal public defenders. So I do not think when it comes to the most serious felonies, there is going to be a meaningful end in sight that will save the taxpayers a bunch of money or me a bunch of time. But it has been an honor for me to work with each of the families that I just mentioned in the 3 cases.
Well, thank you. I didn't mean to imply that you were wasting your time. You're
No,
doing
sir.
what we as legislators have told you to do because we still have the death penalty on the books. I do wonder, though, about the emotional roller coaster for the families of the victims waiting for that to actually occur. And since it hasn't occurred in 20 years, I'm almost wondering, would we be better off to just lock them up and throw away the key in those really horribly severe cases that you were describing. But what you just said is even if we do that, you still have people that will insist that they're innocent, because the moral high ground is on the side of people, because of DeMarlo Berry, even in my mind, it's like, there's always that worry. But if in fact they're locked up in for the rest of their natural lives, that seems to remove that moral high ground where they claim, well, you're going to kill that person that may be innocent. No, I'm not. I'm going to lock him up and throw away the key because he did something so horrific and horrible he doesn't deserve to be in society, and that's what we want to do for the victim's family. But your testimony right now is that even if we eliminated the death penalty, this whole procedure would go on indefinitely no matter what. Is that so? My theory on maybe getting rid of the death penalty to reduce litigation and bring some level of solace for the families of the victims, that's not legitimate in your opinion?
I'm not saying that it's illegitimate, and there is something that's particular to the death penalty, and that is that you have the right to effective assistance of counsel at trial, sentencing. You also have the right of effective assistance of counsel within the meaning of Strickland versus Washington, which sets sort of the constitutional standard at your first post-conviction petition for writ of habeas corpus hearing. So when you say that my trial attorney didn't do a good job, the attorney who represents you in that hearing also needs to meet that Strickland standard, and that is unique about the death penalty in Nevada. That being said, we have lots of other procedural vehicles like the petition for genetic marker analysis, the petition for actual innocence. There are no time limits on those, and they do get filed in the same cases, and we have untimely petitions for writ of habeas corpus that get filed way late that are still heard because they articulate that there's good cause to excuse the procedural bars, etc. So it might look a little bit different, but I don't think that I or my team would be any less busy in these first-degree murder cases.
Okay, well, thank you, Madam Chair. I will say this. I guess the disturbing part in this discussion is for the victims' families to see this constant roller coaster. Either we have justice or the people have been murdered, or we don't. And it just seems to me this yo-yo effect where, okay, we're going to take this guy and he did this horrific thing, rape, murdered, all that, and then it never happens. And then not only that, they're possibly going to get out at some point. It just seems to me like it's incredibly inhumane to do that to the families. In light of Marcy's Law and all that, clearly the people of the state want justice to occur, yet the process that we're describing seems to just drag those people out forever. So I'm sorry, I don't know the exact answer, so I'm just kind of probing, trying to see, is there somewhere in here that we can literally bring justice to the victims' families in particular? Thank you, Madam Chair.
Senator Scheibel, if I may, or Chair Scheibel, if I may respond just very briefly. I think your point, Senator Hansen, is well taken. I think every family is different, but I would note that in my office, before seeking the death penalty, which is a very rare decision, consultation with the victim's family, with their surviving family members, their loved ones, is a huge part of that process. And there have been recent cases where we decided to forego doing that because the family saw this long road and they didn't want to go down it. So their wishes are considered from the beginning, at least by the Washoe County District Attorney's Office, and I anticipate by each District Attorney's Office in Nevada. Thank you.
Thank you so much. All right, I don't see anybody else coming up to give in-person opposition testimony. On SB 350. So we'll go to the phones, please, for opposition on SB 350.
Thank you, Chair. If you would like to testify in opposition to Senate Bill 350, please press *9 now on your phone to take your place in the queue. Chair, the public line is open and working. There are no callers at this time.
All right, then we will go to neutral testimony on SB 350. We'll start with in-person neutral testimony here in Carson City.
Good afternoon, Chair Scheibel and members of the committee. My name is James Zurenda, DZ, URENDA. I'm the Director for the Nevada Department of Corrections. When I go back to the actual language that's actually being changed in this bill or being requested to change, we're just talking about the warrants and the time frames of executing a warrant to what's being said. When I look at the second piece of this language, when I get a warrant for the Department of Corrections to execute somebody, I'm being told I got 15 days. I can't do it, but I have to complete it within 30 days. What that means to me is what Attorney David Anthony said was, it's already in violation of our protocol for the Department of Corrections. We have to transfer the offender up 30 days prior to an execution. We have to prepare, get the victims' families and the victims' notification and get them out to the site if they want to come out. All this takes time, but if I have to do it within 30 days, we're being rushed. When you look at the time frames, that 15 days to me is very difficult for me to even comprehend doing everything I have to do, especially when you're talking about even preparation, training. We have to now prepare and train when there is no execution warrant because 15 days is not enough time. So I create overtime, and I have staff that are on training, periodically, constantly prepping for an execution, even though there's no execution warrants are out there when there's not, because I can't do that in 15 days. To do it in 15 days, we wouldn't have enough time getting people together, the right shifts together, getting the actual enough of all the supplies needed, getting the contracts done. 15 days does seem unreasonable. How far to go out, I don't know what that is, because when longer you add it going out, it does add a lot more stress to the staff and to the offender. Any time that you notify, it's a difference when you get the death sentence to when you get an order of execution to actually execute the individual. When you get the actual order to execute somebody, it puts the offender on notice that this is going to happen in a certain time frame. We start prepping that individual to be able to prepare for this while we're doing other stuff, and extending that out. It puts more stress on the staff from working with the offender, from notifying the offenders that they're actually going to be executed. All that time frame going out is like you're holding it over everybody's head, including the staff. So I'm not sure what that far end number should be, but the 15 days does seem unreasonable and to me should be expended further out than that. When you talk about the actual language of this, I'll answer what Senator Ellison mentioned was, I don't see either of these languages shortening any time of someone being on death row. If you are in death row 22 years, and this language was 30 years ago that was changed, they're still going to be on death row for 22 years. So I don't see how that's going to change. It's really the execution of the actual warrant when we get it. But I just want to make that clear that it does affect us, that we are in violation of our protocol when it is only the 15-day notice that I get within 30 days, because I can't complete our protocol within 30 days.
Thank you so much. All right. Anybody else wishing to give neutral testimony? I don't see anybody in person, so we'll go to the phones, please, for neutral testimony on SB 350.
Chair, if you would like to testify as neutral for Senate Bill 350, please press star 9 now on your phone to take your place in the queue. Chair, the public line is open and working. There are no callers at this time.
All right, that concludes testimony on SB 350. I'll invite the sponsor back up to give closing remarks.
Chair Scheibel, members of the committee, James Orchall, Senate District 21, thank you for hearing Senate Bill 350. I do want to thank Ms. Noble. She took a lot of time out of her schedule for a Zoom meeting with Mr. Anthony and Mr. Betancourt and myself, and I know we were trying to hammer things out, and I appreciate her time and working with us on the bill, and I know we couldn't get there, but I do appreciate that. With your deference, Chair, may I allow Mr. Anthony just to address a few points? Thank you.
Absolutely.
Thank you. This is David Anthony for the record.
Just a couple closing comments. I would certainly reiterate the points made by Director Zarenda about all of the things that have to occur in the current very compressed time frame. He made comments from the perspective of corrections. There's a lot of other stakeholders. One of them that we haven't mentioned yet is the court system as well. Execution warrant litigation involves a lot of effort and expenditure of resources by the courts, both at the trial court level and also in the Nevada Supreme Court. There are specific rules about notifying the court when there are execution warrants. That puts, there's also an element where it puts a lot of stress on the staff that are in charge of the court system to be able to field these time-sensitive inquiries when we're talking about whether someone's going to get a competency hearing, whether or not a method of execution should be challenged, or whether there's been enough opportunity to apply for a pardon with the Pardons Board. So I would just reiterate that point and also mention the pressure that can be put on the court system as well. And I think that that's another factor that is worth mentioning. Just to very briefly respond to Ms. Noble from the DA's office, I really enjoyed the opportunity to speak with her about the legislation. She and I find ourselves on opposite sides of the aisle, and I certainly respect her professionalism and enjoy working with her. The only thing that I would take issue with, and this might just be a minor point, but that is that there's an incredible difference in terms of expenditure of resources when we're talking about a non-capital case. Non-capital cases have a discretionary appointment of counsel mechanism. Many cases that are life without parole cases are litigated by the defendant pro se, seeking appointment of counsel, but that is a discretionary process. Once that person goes through the system once, there are also a lot of procedural barriers that exist to bringing any sort of additional litigation. To the credit of Nevada, we do have an innocence provision and a provision for genetic marker analysis, but I do think that there's a significant difference between cases involving life without parole versus cases with the death penalty. And so with that clarification, I'll submit the matter to the committee. Thank you for having me this afternoon.
Thank you both so much. And with that, I will now close the hearing on SB 350. I think that finally takes us to the end of our agenda today, where we have public comment. Anybody wishing to give public comment in person is invited to the front now in Carson City and Las Vegas. I don't see anybody coming forward in person to give public comment, so we'll go to the phones, please, for public comment.
Thank you, Chair. If you would like to provide public comment, please press *9 now on your phone to take your place in the queue. The public line is open and working. There are no callers at this time.
All right, then that brings us to the conclusion of our meeting for today. We do have a meeting again tomorrow, same time, same place. Until then, we are adjourned.